Article 348(2) of the Indian Constitution, the governor of a state may, with the previous consent of the President, authorize the use of Hindi or any other language used for any official purposes of the state, provided that nothing in the aforesaid article shall apply to any judgment, decree, or order passed or made by high courts. In fact, Indian legal system is not indigenous, but based on British Anglo-Saxon legal system. Legal language is developed on the background of English language. English language is a good mixture of German and Roman language, especially the words from Latin, German, and French, which are found in English language, make it difficult for the countries who have wholly adopted English language. Therefore, many Latin words are still being used, such as ipso facto, suo motu, ab initio, status quo, sine die, ultra-virus, res judicata, just civil, etc. As per Indian legal and constitutional history, the Indian legal system starts from the British period, because they had provided the system of courts with the powers and functions of judges and jurisdiction of powers of all courts, with legal jurisprudence, CPC, CRPC, IPC, Evidence Act, and other acts, which were provided and written in English language. On this very auspicious occasion, I welcome our distinguished guest speakers, our teachers, our students, and the staff of the college. Thank you very much.
Thank you, sir. You have provided very important knowledge about the English language and the law. Now I invite Dr. Asta Suman ma'am for providing keynote.
Good morning, all of you. Honorable President, SKJ Law College, Honorable Madam Secretary, Dr. Ujjwala Mishra, respected Principal, Dr. K.N. Tiwari, Director Sir Jayant Kumar, our Vice Principal, Professor B.M. Azad, our faculties, Professor Pankaj Kumar, Dr. C.S. Azad, Dr. Archana Anupam, Dr. S.P. Chaudhary, our guest of honor, Dr. S.K. Paul, Principal, SRPS College, Jaipur, former Head and Professor, University Department of English, BRA, Bihar University. On behalf of SKJ Law College and from English Department, it's a pleasure and privilege to welcome all of you on this platform. We are here to share our thought over the topic, Command of English Language, a key tool for success in law. English is known to be the universal language used by people all over the world to communicate. As per English, for law is concerned, it is one of the many forms of English that is used in law. Over some 700 years, the language of law developed through waning and waxing of different languages and influences: Celtic, Norman, Latin, and French. Latin was required language of court proceedings a long time back, as was French for a period. During that time, statutes were also in Latin and French. English was still developing, evolving, and absorbing words from many languages. Latin and French remained more prominent languages in the legal world despite legislation to enforce English as the language of law. English as the language of law came into prominence from 18th century, but Latin and French words survived then and continue to survive now in the language of law, though equivalent words of daily use as English are available. English is a technical language, specifically originated as a language for legal professionals, such as judges, lawyers, legal assistants, etc. Legal English is not a native language for these professionals. Therefore, they are required to learn this language from a technical context in order to perform well in the field of law. Learning legal terms is important for the career if you are studying law, regardless to the state or country. The main reason behind this is the rise of globalization. Since a lot of people study from one state or country and apply their learned skill by moving to another state or country, it is important that one should be able to communicate well by interacting others. English is a second language for many people. Therefore, learning professional law definitely indicates that one should learn the English terminologies in the same area. However, as a law student, you can come across various challenges. In the study of law specifically, language has great importance. Cases turn on its meaning that judges ascribe to words, and lawyers must use the right words to effectuate the wishes of their client. Learning the meaning of these words is essential to understand any case or discussion which uses them. It has been said that you will be learning a new language when you study law, learning new words that you probably haven't encountered before. These words and phrases have meaning only as legal terms. As for example, there are many words which have different meaning in law. Malice, as for example, when used in the law of defamation, doesn't mean hatred or meanness. It means with reckless disregard for truth. Similarly, consideration in contract law has nothing to do with thoughtfulness. It means something to value given by a party to an agreement, so on and so forth. Moreover, the British English became the language of law. English in India is the language of law as well. Without the basic skills in English, a lawyer who has studied in a vernacular medium can only go so far, while practicing law in the local language helps certain groups of clients only. India's legal system and education are legacies of its colonial past. Legal education was formally introduced in India in 1857 in three different universities, Calcutta, Bombay, and Madras. Anyone who learned English was eligible to study, qualify, and practice law. As India followed the British judicial system to a great extent, the Indian legal lexicon includes a range of terms in English. The Legal Education Regulator, Bar Council of India, requires English to be included as a compulsory paper in all courses in law, even though the course itself can be delivered and students tested in any medium. This holds even for the 3-year LLB program. However, studying law in the mother tongue helps students who want to practice law in lower courts and in their native places. At the same time, it limits the lawyer's career prospects. English language has highest importance in law and in legal profession. Our laws are drafted in English and then translated in regional language. Most of the laws, statutes, rules, and regulations in other countries have been written in English. The High Courts and the Supreme Courts exclusively use English as its communication language. As English-speaking persons are increasing countrywide, without being the master over the language, there would not be a bright future for them. This and many other reasons make English indispensable for legal profession. Thank you. Uh,
Well,
now I wish to invite Professor B.M. Azad uh, for for sharing his views over the related topic. Thank you.
Respected Honorable President Shri S.K. Misra ji, respected Honorable Secretary Professor Dr. Ujjwala Misra ji, respected Director Shri Jayant Kumar ji, respected Principal Dr. K.K.N. Tiwari ji, our Honorable guest Professor Dr. S.K. Paul, University Department of English, Bihar University, organizer Professor Astha Suman ji, Professor Pankaj ji, Professor Dr. Archana Anupam ji, Professor Amitabh Sahai ji, Professor Dr. S.P. Chaudhary ji, Professor Dr. C.S. Azad ji, Professor Seema ji, Professor Anand ji, and all my dear students. English in some way has become an international language of dispute resolution. So why is English and command of English language a key tool for success in law? Legal system was introduced in India by the British in 1726 based on recorded judicial precedents, that is records of previous courts decisions and rulings of the Privy Council. So all of these are in English language. Therefore, the knowledge of English language becomes important so that we can carefully and effectively cite those precedents. Again, the judges in courts under British were used to be English men. They were unable to interpret and understand the Hindu personal law governed by Shruti, Asmriti, Vedas, etc. As well as Muslim personal law, they were unable to understand the provisions of the Quran Sharif written in Arabic. So English was established as the language. Now, major legal texts such as theory of punishment, theory of law by Salmon, Austin, rule of law by Dicey, and various other crucial texts have one thing in common, that is English. Even the buzzword social engineering was described by Dean Roscoe Pound in English. So the major ideas and concept that form the foundation of law, that is jurisprudence. Jurisprudence too is dominated by English. Therefore, to understand, apply and implement those concepts, command in English must. So I end my input by saying that command in English language is clearly a key tool for success in law. Thank you.
Now I wish to call Dr. Archana Anupam with an important viewpoint over the topic. Please come back.
All of you, myself Archana Anupam, College President Sri SK Misra ji, Secretary Dr. Ujjwala Misra ji, Director Sri Jayant Kumar ji, Principal Dr. KK Tiwari, Vice Principal Sri BM Azad, Coordinator Dr. Astha Suman, Co-Coordinator Pankaj Kumar, Professor SP Chaudhary, Professor CS Azad, Professor Abhishek Anand, and continue my article. When emergency strike, immediate and effective communication is key. A crisis is no time to stop for translation. Within the greater field of criminal justice, law enforcement officers act on the front line of the law to maintain authority and keep us safe. They are known on the street, at the borders, and in our airports, seaports, parks, and prisons. When officers are able to speak the same language as the individuals they encounter, they enhance communication, promote safety, and prevent dangerous misunderstandings or unnecessarily violent escalations. In recent years, highly televised protests and shooting involving police officers and racial or ethnic minorities are all too familiar and continue to illustrate the struggle for representatives of the law to build trusting relationship with the communities they serve. Sharing a common language is one way to drastically reduce communication, read roadblocks, and foster better understandings. More than 1 in 5 US residents speak a language other than English at home. That's almost 62 million people, a record breaking figure. Furthermore, over 25 million US residents, roughly 9% of the US population, report that they speak English less than very well. Herein lies the enormous demand for a multilingual law enforcement workforce. If the community doesn't speak English, officers need to be able to connect their languages. The topic, a call for bilingual law enforcement officer. Language barrier often in tandem with ethnic disproportions in the workforce regularly prevent the law enforcement system from functioning as well as it could. Nothing that about 10% of Sacramento's police force is of Latino descent, while the state is home of approximately 15 million Latinos. Carlos Quiroz of California's Latino Leadership Council explains, if the police do not properly reflect the community they serve, it is difficult for the community to see it as a force that represents them rather than one that polices them. This leads to crimes not being reported, witnesses not coming forward, and a community preyed upon by criminals who knows their victims won't have any recourse. The Department of Justice and the Equal Employment Opportunity Commission suggests some reasons why this imbalance remains so prevalent in their report. Advanced diversity in law enforcement due to underrepresentation, young people including heritage speakers of critical language often ignore the possibility of law enforcement career because they don't identify with strong role models in the field who share their background. Hearing criteria for many agencies that require US citizenship also poses a challenge, preventing a language-rich pool of candidates from applying to positions. The report also notes that the cost and complexity of application procedures, including multiple exams, further alienates otherwise qualified prospective applicants. To curb recruitment obstacles, some agencies have begun offering bonuses and other incentives to prospective and current officers who test proficient in a language other than English or who regularly speak another language as part of their main work responsibilities. Law enforcement, law enforcement's role requiring language skills. The United States Office of Justice Programs formally defines law enforcement professionals as any officer, agent, or employee of a state, unit of local government, or an Indian tribe authorized by law or by a government agency to engage in or supervise and prevention, detection, and investigation of any violation of criminal law or authorized by law to supervise sentenced criminal offenders. About 18,000 federal, state, country, and local agencies in the United States, each company between 1 and 30,000 law enforcement professionals. Most of these implies are sworn officers who are authorized to make arrest and carry a badge and firearms. A smaller number of non-sworn civilian personnel support their reports. In 2012, the Uniform Crime Reporting Program reported over 1 million state and local law enforcement employees nationwide, more than 7,15,000 of whom were sworn officers. Absolutely, all law enforcement role at the local, state, and federal level are improved when officers have advanced language skills. More specifically, some responsibilities performed daily throughout the sector at required officers to communicate in a language other than English include addressing participants present at an incidents in the timely and receiving fashion of fashion to diffuse fear or tension and to restore community moral, speaking with witnesses or victim relatives and taking accurate testimony, investigating criminal activity, and collaborating with colleagues across departments and educating the public while developing trusting relationship through speaking roles at schools or community special interest group. Thank you so much.
Thank you, ma'am. Thanks. Now I would like to invite Dr. S.P. Chaudhary, sir, with his viewpoint over the topic. Thank you.
Respected persons present in today's webinar, such as our college president, Honorable Sri S.K. Misra sir, Secretary of the college, Dr. Ujjwala Mishra, Madam, Director of the college, Sri Jayant Kumar Sir, Principal, Dr. KKN Tiwari Ji, guest of the webinar, Professor Dr. SK Paul Sir, Professor Dr. AK Bachchan, our college Vice Principal, Professor BM Azad Sir, our colleagues, Professor R.S. Sahai, Professor Pankaj Kumar, Dr. Archana Anupam, Dr. C.S. Azad, Dr. Simaji, Professor Madhu Kumari, and Dr. Astha Suman, and also all participants in which other faculties, students, and staff of the college. I am appreciate to program coordinator that who gave me some time for express the topic command of English language, a key tool for success in law. Means I would like to an advocate or law student. You know that the topic is important or relevant for the legal professions. In fact, the command of English language is the key to success in any profession in which word count. But especially advocacy is a profession where command language, both in written and spoken, plays a decisive role. Since English is the language in which many materials required for an advocate are available, no advocate can attain professional success without having a good command over the words and the language he handles. Next, an advocate needs language skill in diverse occasions. He or she needs language skill while presenting a case in the court or persuading a judge to a particular point of view or convincing a client about a complex issue. Therefore, an advocate learned that the meaning of a word may change from time to time, place to place, and person to person, depending on the context in which it is used. At last, I have wanted to say that you should choose your words well and present them well when making an oral presentation. A good speech prepared well in advance can be ruined by a bad delivery. And remember not to use uncivilized and offensive, not to use uncivilized and offensive expression. No civilized person dares to speak or write in public. Therefore, all persons who join legal profession, they should learn and preparation legal language in English, then they success in on professions. Thank you very much.
And further, I would like to invite Professor Professor Pankaj Kumar, with his opinion over the topic of command of English.
Thank you, madam, giving the opportunity to speak on the topic. First of all, I respected our President Sri SK Mishra sir, respected Secretary ma'am, Dr. Ujwala ma'am, who always inspire us to do such like a webinar or seminars to encourage the knowledge of a students and also uh, take part the teachers in the this type of activities. Respected Director Sir Sri Jayant Kumar, respected Principal Sir Dr. KK Tiwari, respected Vice Principal Sri Brajmohan Ayad Sir, respected our faculty members of my college, Dr. Archana Anupam, Dr. Seema Kumari, Sri Madhu Kumari, Rai Amitabh Sahai Sir, Dr. S.P. Chaudhary Sir, and Dr. Astha Suman ma'am. Our, our respected Honorable Chief Guest, Dr. S.K. Paul Sir, University Department of English, BRABU Muzaffarpur, my dear students who are connected with this webinar. The topic, today's topic is command of English language, a key tool to success in law. This is a very important topic to discuss about the students of law, because for the students of law, English language is very necessary in his academic career and further success in his future. As well, all know that English is known to be the universal language. Legal education was formally introduced in India in 1857 in the universities of Calcutta, Bombay, and Madras. Anyone who learned English was eligible to study, qualify, and practice law. Legal language means a language used by the person connected to the legal profession. The language used by the lawyers, jurists, and the legislative draftsmen in their professional capacity. Law, being a technical subject, speaks through its own register. So, for the student of law, the subject legal language and general English is almost found in all universities as a paper, and drafting, pleading, and conveyancing is also possible in only in English. Although English is not the most spoken language in the world, it is the official language in 53 countries and is spoken as a first language by around the 400 million people worldwide. But that's not all, it is also the most common second language in the world. For the students of law, one paper as a legal language and general English compulsory as knowing pleading, drafting, and conveyancing is also important for the lawyers. To know the historical development of the constitution before the independence, it is necessary for the law students during colonial period from the Charter Act 1756 to Regulating Act 1773, and later on Government of India Act 1858, Government of India Act 1919, and Government of India Act 1935. Our constitution is the development of uh, these acts, which is drafted by the Britishers in English. Our main penal code, that is Indian Penal Code 1816, is drafted by the first Law Commission headed by the Lord Macaulay. Indian Contract Act, Evidence Act, and the Civil Procedure Code 1908 still is present in India, and time to time it is amended, but although its name is 1908, 1860 likewise. An example from, I would like to give you an example of my personal experience that how English is important for the student of law and the persons who are like to make career in law. If you are given any examination and question paper are in two languages, one is English and other is Hindi or others, then in instruction column it is written that in question paper, if there is any discrepancy in English and Hindi version, the English version is to be treated as correct. This is the importance of English language. Thank you.
Thank you, sir. Now I very humbly wish to invite our guest of honor, Dr. S.K. Paul, Principal, SRPS College, Jaipur, former Head and Professor, University Department of English, PRA, Bihar University. Sir, you are getting my voice?
Yes.
Yes, sir, please.
Yes. Good morning and all my good wishes to all the members of the SKJ Law College, such as the President, the Vice President, Chairman, Principal, and all esteemed faculties of the SKJ Law College, and dear participants. Thank you for inviting me to deliver lecture here today. I feel pride that you have given me this opportunity. So I here start right now. Command of English, English language, a key tool for success in law. The lawyers do not write plain English. They use 8 words to say what could be said in 2. They use arcane phrases to express commonplace ideas. Seeking to be precise, they become redundant. Seeking to be cautious, we become verbose. Our sentences twist on phrase within clause, glazing the eyes and numbing the minds of our readers. The result is a writing style that has, according to one critic, 4 outstanding characteristics when the common law was transplanted to America. The writing style of the Old English lawyers came with it. In 1817, Thomas Jefferson lamented that in drafting statutes, his fellow lawyers were accustomed to making every other word a said or aforesaid, and saying everything over 2 or 3 times, so that nobody but we of that craft can untwist the diction and find out what it means. Legal writing style long remained a subject of jokes and ridicule, but a reform movement started in the 1970s. A few legislatures passed laws that require documents such as insurance policies and consumer contracts to be written in plain language. Banks, manufacturers, and other business discovered that documents written in plain language can reduce costs and increase profits. For example, an automaker's clearly written warranty can help sell cars, and a lender's clearly written loan agreement can reduce costly defaults and foreclosures and reduce the amount of staff time spent answering questions from puzzled citizens. The movement toward plain legal language is changing the legal profession itself. Most law schools now teach the plain language style in their legal writing courses. Court rules have been rewritten to make them easier for lawyers and judges to use. Diligent committees of experts are rewriting packaged jury instructions to help make legal doctrines understandable to the jurors who must apply them. Practicing lawyers become eager students in continuing legal education courses that teach clear writing. The legal profession has made progress, yes, but the victory is not yet won. Too many law students report back from their first jobs that the plain language style they learned in law school is not acceptable to the older or senior lawyers for whom they work. Too many estate planning clients leave their lawyer's office with a will and a trust agreement in hand, but without fully understanding what they say. Too many people merely skim or even ignore the dense paragraphs of securities, disclosures, credit and agreements, apartment leases, cell phone contracts, and promissory notes, preferring to rely on the integrity or mercy of the author rather than to struggle with the author's legal prose. Omit surplus words. First, omit surplus words. As a beginning lawyer, one is often assigned to assist a senior business litigator. He would dislike verbosity. When one would bring him what one thought was a finished piece of work, he would read it quietly and take out his pen as one watched over his shoulder. He should strike out whole lines, turn clauses into phrases, and turn phrases into single words. One day at lunch, uh, um, once he asked him how he did it. He shrugged and said, "It is not hard, just omit the surplus words." How to spot bad construction? In every English sentence are two kinds of words, working words and glue words. The working words carry the meaning of the sentence. Some are working words, maybe like these, working words carry meaning and sentence. The others are the glue words, the, of, and the. The glue words do perform a vital service. They hold the working words together to form a proper grammatical sentence. Without them, the sentence would read like a telegram. But if the proportion of glue words is too high, that is a symptom of a badly constructed sentence. A well-constructed sentence is like fine cabinet work. The pieces are cut and shaped to fit together with scarcely any glue. When we find too many glue words in a sentence, take it apart and reshape the pieces to fit together tighter. Avoid compound constructions. Compound constructions use three or four words to do the work of one or two words. They suck the vital juices from your writing. You saw some examples here. You can see some examples here with respect. Common, so compound words, and then simple words. At the point in time, it is compound. Simple would be then. By means of, use simple. By reason of, use simple. Because of. By virtue of, either by or under. For the purpose of, that is to. For the reason that, because. So this way we have I have selected some compound sentences and their substitution in substitution for simple. Now avoid word wasting idioms. Once you develop a distaste for surplus words, you will find many word wasting idioms to trim your own sentences with no loss of meaning. For instance, the fact that the defendant was young may have influenced the jury. What meaning does the fact that add? Why not say the defendant's youth may have influenced the jury? The fact that is almost always surplus, so it may be seen here. Verbose, the fact that she had died, concise, her death. Simple two words. Verbose, he was aware of the fact that, concise, he knew that. Despite the fact that, concise, although, even though, because of the fact that it is purpose. Likewise, words like case, instance, and situation spawn verbosity, verbose. In some instances, sometimes the parties can. So, concise substitution is parties can. In many cases, you will find concise. Often you will find that was a situation in their the court. So concise, which the court disability claims are now, disability claims are more. So other examples of common word wasting idioms that you eliminate with no loss of meaning are verbose. During the time that, during or while, for the period of, concise for, insofar as is concerned, omit it and start with the subject. There is no doubt but that, concise, doubtless, no doubt. Verbose, the question as to whether, so simple, concise, whether, the question whether. This is a topic that, so concise, this topic, until such time as, until. A sound knowledge of English grammar and composition helps improving use of verbs and tense and their use in most communicative way as drafting a lecture or proceeding of the court or office. It also helps in further verbal expression. In the court, judges uh, look into the grammatical aspects of the written text first, such as verb, tense, or prepositions. A judge often notices if the incidents or events truly happened. He often determines the truth through the words used in the draft and the sense that it reflects whether the event occurred in the past or in present or in future. He tries to find out the meaningful sense. Do not use redundant legal phrases. Why do the legal people use the term null and void? According to the dictionary, either null or void by itself would do the job, but the lawyer's pen seems impelled to write null and void as though driven by primordial instinct. An occasional lawyer, perhaps believing that null and void looks naked by itself, will write totally null and void, or perhaps totally null and void, and of no further force or effect whatsoever. The phrase null and void is an example of coupled synonyms. Coupled synonyms, a pair of string of words with the same or nearly the same meaning. Here are the other common examples of coupled phrases. Alter or change, last will and testament. So alter or change, last will and testament, confessed and acknowledged, made and entered into, convey, transfer, and order and direct, set over, for and during the period, peace and quiet, force and effect, rest, residue, and remainder, free and clear, save and accept, full and complete, suffer or permit, give, devise, and bequeath. So coupled synonyms have ancient roots. Some of them come from the days when lawyers in England needed to make themselves understood to both the courts, which used Latin and later law French, and to common folk who used Old English and later Middle English. Use base verbs, not nominalizations. As its core, the law is not abstract. It is a part of a real world full of people who live and move and do things to other people. Car drivers collide, plaintiffs complain, judges decide, defendants pay. To express this life and motion, a writer must use verbs, action words. The purest form is the base verb, like collide, complain, decide, and pay. Base verbs are simple creatures. They cannot tolerate adornment. If you try to dress them up, you squash their life and motion. The base verb collide can be decked out as a noun collision. Likewise, complain becomes complaint, decide becomes decision, pay becomes payment. A base verb that has been turned into a noun is called a nominalization. Lawyers and bureaucrats love nominalizations. Lawyers and bureaucrats do not act, they take action. They do not assume, they make assumptions. They do not conclude, they draw conclusions. If you use nominalizations instead of base verbs, surplus words begin to sound like gnats. Please state why you object to the question. Comes out like this. Please make a statement of why you are interposing an objection to the question. The base verb state can do the all alone, but to get the same work out of the statement, you need a supporting verb, make, an article a, and a preposition of. The word of objection attracts a similar cloud of surplus words. Prefer the active voice. When you use a verb in the active voice, the subject of the sentence does the acting. John kicks the ball. John kicks the ball is in the active voice. John is the subject and John does the acting. He kicks the ball. When you use a verb in the passive voice, the subject of the sentence is acted upon. The ball is kicked by John is in the passive voice. Ball is the subject and the ball is being acted upon. It is kicked by John, active. John kicked the ball, passive. The ball was kicked by John. The two sentences mean the same thing, but observe that sentence in the passive voice is longer than the sentence in the active voice. In the active voice, the passive can create ambiguity. The passive voice takes more words than the active voice, but that is not its only disadvantage. The passive voice can be ambiguous. With its active voice, you can easily tell who is doing what to whom. With the passive voice, however, the writer can hide the identity of the actor. That construction is called the truncated passive. For example, the ball was kicked. Who kicked the ball? We have no way to know. The actor is hidden in the fog of truncated passive. Bureaucrats love to write in the truncated passive because it lets them hide in the fog. The reader cannot discover who is responsible for the action or the lack of it. Use short sentences. For centuries, English-speaking liars have been addicted to long, complicated sentences. The long sentence began habit began back when English writers used punctuation to guide oral delivery rather than to help convey the meaning of a sentence. In law, the long sentence habit
Thank you, sir. Uh, now I wish to invite Dr. A.K. Bachchan, Professor and Head
exceptions,
PG Department of the
exceptions, and conclusions, in particular statutes, regulations. Arrange your words with care. Avoid wide gaps between the subject, the verb, and the object to make is one. In seeking to understand a sentence, the reader's mind searches for the subject, the verb, and the object. If those three key elements are set out in the order close together near the front of the sentence, then the reader will understand quickly. When necessary, make a list. Sometimes the best way to present a cluster of conditions or exceptions or other closely related ideas is with an introductory clause followed by a list. Put modifying words close to what they modify. In some languages, the order of words within a sentence does not affect the meaning of the sentence, but in English, word order does affect meaning, as the sentence shows. The defendant was arrested for fornicating under a little used state statute. Modifying words tend to do their work on whatever you put them there. Therefore, as a general rule, put modifying words as close as you can to the words you want them to modify. That will help avoid sentences like this. My client was discussed your proposal to fill the drainage ditch with his partners. Being beyond any doubt insane, Judge Weldon ordered the petitioners transferred to a state mental hospital to bring a noun chain under control. Lock of any of the descriptive words that are not essential. If that is not enough, then insert some words to break up the chain, like this. Draft regulations to protect the rights of uh, lives of laboratory animals. Avoid multiple negatives. Beware of sentences that contain more than one negative expression. It shall be unlawful to fail to is an example of a double negative. The grammar is proper, but the construction is distracting. It makes the reader's mind flip from yes to no and to yes. In addition, ordinary negative words and prefixes such as not, int, and non. Many other words operate negatively. For example, terminate,
Remind
void,
me,
denial,
name the time, sir.
accept, unless,
Getting
and
late.
other. Avoid cosmic detachment. Every legal problem involves people. Without people, there would be no legal problems. Yet, legal writing too often ignores people and addresses itself to some bloodless, timeless, cosmic void. For example, Here is the opening substantive sentence of the federal. Now it is the time
हेलो
of
सर,
punctuation.
आवाज आ रही है? कौन
हाँ,
सा?
आवाज आ रही, हाँ, आवाज आ रही है.
थोड़ा कंक्लूड
बस
किया जाए
बस
5
now
मिनट.
I'm about before 5
जी
minutes.
जी, थैंक यू सर.
In 5 minutes, sure. Punctuate carefully. As English speakers in the 21st century, we are accustomed to the idea that punctuation affects meaning, but our punctuation system would have seemed odd to an English speaker in the early 17th century. The punctuation used in those days had evolved from earlier system of dots, lines, and slash marks used by the Greeks and Romans. The Greek and Roman systems were not syntactic. That is, punctuation marks were not intended to affect meaning and were not based on grammar as our marks are today. Rather, the Greek and Roman marks served a rhetorical function by dividing segments of a discourse according to a formal rhetorical patterns and an elocutionary function by indicating where to pause and breathe when reading the text aloud. Like the Greek and Roman systems, the punctuation used in early 17th century English was not syntactic. Its function was primarily rhythmic and elocutionary. So this way, ladies and gentlemen, I have finished my lecture. I have completed my lecture for today. Thank you to all of you again, especially the organizing committee of this webinar and all the participants.
Thank you, sir. Thank you. Now I wish to invite Dr. A.K. Bachchan, Professor and Head, PG Department of English, LNMU Darbhanga. Please, sir. So
Thank you.
only 5 minutes are there. Yes.
Okay. Respected Director, SKJ Law College, Muzaffarpur, Sri Jayant Kumar, Dr. Astha Suman, Lecturer and Program Coordinator of this webinar, SKJ Law College, Muzaffarpur, and the guest of honor, Professor S.K. Paul, University Department of English, BRA, Bihar University, Dr. K.N. Tiwari, Principal, SKJ Law College, Muzaffarpur, faculty members of SKJ Law College, and my dear participants. Thanks to SKJ Law College and the director who have given me this opportunity to be with you, all the participants, and the coordinator and the director have chosen a very relevant topic, command of English language, a key tool for success in law. You know, a key to success in any profession, any job, any profession is the command of English language in written and spoken form, and it plays an important role. It plays a vital role. A lawyer needs language skills in diverse occasions. He needs it while presenting a case in the court, or he needs it in persuading a judge to a particular point of view, or he needs it in convincing a client about any complex issues, matters. Sorry. He cannot bring the rightness of the cause, which he argues to the attention of the judge, without language skills. In the court of law, in a court, in cross-examination, a lawyer requires language ability in asking right questions and in using the right words and in the right tone and tenor so as to elicit, so as to bring out right answers from the witness. To study a provision of law which might be drafted in a highly sophisticated manner, highly sophisticated style, or in a quite simple but deceptive form, or in a quite simple and deceptive manner, the lawyer requires language skills. The lawyer requires a language skill because in analyzing each and every word and its meaning, a lawyer requires language ability. If he is preparing a deed of contract or he prepares a will or a petition, he requires the ability to find, to choose the right words, to choose the right sentences that would serve the purpose of such a deed or petition. So we can say that words are the vehicle of one's feelings, one's thought. One cannot think, one cannot converse with, one cannot talk or converse without using words. So no lawyer, no advocate can attain professional success without having a good command over the words and language he uses. If there is difficulty for others to make out what an advocate writes, what a pleader writes, what a lawyer writes or speaks, it may be because of his mind. Because of his mind is still unclear of the concepts, of the principles. He deals with obscurity in language, is probably the result of obscurity in thinking. Inherent infirmity of words, use of words in a problem is an inherent infirmity of words is a problem, but the solution to that problem is continuous learning. Continuous learning and a skillful use of his feelings, thoughts. A word may mean one thing in one context, but another thing in another or quite different context. A lawyer must therefore exercises great care in using each word in its right context. A lawyer must prefer using plain and simple words to communicate effectively before the judge. There is a book by Lord Denning, or he has written in that book, The Discipline of Law is the name of the book. And he has written, Lord Denning has written in his book, in which he narrates the extraordinary efforts he had taken to acquire his language skills. And being an English native, he was called upon to serve the bar. He tried his best to be well equipped, to be proficient in words drawing on English literature and reading. Reading the works of Shakespeare, he also read other writers. He read Macaulay, Carlyle, Milton to improve his language ability. So reading different books gave him not only a wide vocabulary of words, but also a good familiarity of the meaning those great writers assigned to the words. So he read or he learned that the meaning of words may change from time to time. Meaning of words may change from place to place and person to person, depending on the context in which the words are used. Then he practiced the words and their language pattern continually so as to get proficiency in both writing and speaking. So we can say that in order to succeed in the profession of law, a lawyer cultivates the practice of building command of language too, to develop to enhance and develop speaking skills needs more practice, more experience compared to developing skills in writing. Whenever you speak, make your voice pleasing to others. So try to be pleasing to others. Whenever you speak, use the correct pitch, use the right pitch, use the right tone so that you are audible to all those who pay attention to your speech without any kind of a strain. Use right pronunciation, use right rhythm and intonation to make your speech well and attractive, for which you have to practice voice articulation exercises. Pace, speed must not be too fast. Whenever you speak, your pace must not be too fast or too slow. Don't use long-winded, long sentences. So Lord Benning advises us not to use long words, not to use long sentences unless we are sure that our audience understand it. So he further very well reminds us not to use an over long sentences. When a long draft is being prepared by the lawyer, long draft, whenever it is being prepared, make it into paragraphs, make it into sentences. So if a sentence is unduly long, split it up into short sentences, short ones, and use punctuations. So you can use dash, you can use colon, you can use semicolon in making your long sentences meaningful and effective. So lawyers should choose their words well and present them well when making an oral presentation in the court of law. A good speech that is prepared well in advance can be ruined by a bad delivery. So you should not forget that the spoken and the written words are quite different. If you prepare a draft for a speech, write it in a style you orally deliver it before the audience. You should never try to learn the speech by heart, but you should try to think of the points in it, and you should try to explain them during your delivery, during your speech. So writing English perfectly is as important as speaking it in the right way, in the proper way. So don't use uncivilized, don't use offensive expressions in public. So bad English will damage your reputation, your name and fame. People get distracted by grammatical or spelling errors. A lawyer's profession requires to be well equipped in English language. It is a royal profession, and lawyer's profession requires you to be well equipped in English language. Every source of knowledge in law, right from the textbooks to enacted laws, to reference documents of judgments, exists in English language. So every lawyer cannot survive in the profession without using proper language skills. Sometimes it is being asked, why is it important for a legal profession to have command over language? So in order to talk to them regarding legal matters, you must adapt their language, that is English used in law, that is particular to their reason. English is, of course, a second language for many people. Learning professional law definitely indicates that you should learn English terminologies. You should learn English terminologies in the same area. And if you succeed in the profession of law, you must seek to cultivate command of language. Words are the lawyer's tools of trade, business, trade. If you address the judge, if a lawyer addresses a judge, it is your words, it is the lawyer's words which counts most. Words are the vehicle of thought. Without the basic skills in English, a lawyer who has studied in a vernacular medium can only go so far, while practicing law in the local language helps certain groups of clients. It may help some certain groups of clients while the lawyer speaks the local language. The lawyer himself has to be reconciled to spending his entire career practicing in the lower courts. So legal English, we can say legal English has particular relevance when applied to legal writing and the drafting of written material, including legal documents, legal contracts, licenses, etc., court pleadings, summons, briefs, judgments, etc.
Thank you, sir. Sir, आवाज आ रही है? Sir, we have limited time in Zoom app.
Okay.
Technical problem. Sorry, sir.
Okay, thank you.
Delivered very important
So,
and valuable knowledge for our student. We have exempted question hour due to lack of time.
I am concluding. So I thank the faculties of SK Law College, Muzaffarpur, who have given this opportunity to me. So I thank you all.
Thank you.
Organizers.
Thank you, sir. Now I invite our principal, Dr. K.K.
So I have a
Tiwari, sir,
meeting
for
with the Vice Chancellor. So I'm
giving thanks.
getting very late, 20 minutes late.
Good morning, sir. Good morning to everybody. Really, sir, we are highly thankful to you for your colleagues and deep language, deep knowledge, just like Pacific Ocean. Particular to our honorable guest, Professor Samiran Pauls and Dr. A.K. Bachchan. Law is the body of rules and principles recognized and applied by the state and the administration of justice, basic principle of law. Since our honorable guests have already detailed everything, thereafter I think nothing remains to say. Therefore, I am communicating my heartiest thanks to all the honorable speakers, and we are highly thankful to our honorable President, Sri S.K. Misra, Madam Secretary Dr. Srimati Ujwala Misra, for their extraordinary and remarkable thanks to organize such types of academic programs. Since I realize the immense pleasure, and this is the matter of so enjoyment that we are online together, sir, witnessing the topic of the day titled as the command of English language, a key tool for the success in law. At first, I extend my sincere thanks to Professor Dr. S.K. Paul, PG Department of English, Bihar University, Muzaffarpur, for his excellent delivery on the subject matter. I am thankful once again to Dr. A.K. Bachchan, Professor and Head, PG Department of English, Late Narayan Mithila University, Darbhanga, who gave his valuable time to make the program success. Many thanks to you, sir. I am thankful to our director, sir, Sri Jayant Kumar, who is always performed a duty of a good guardianship and gives us proper guideline and encouragement to the youngsters like me. I communicate my happiest thanks to our distinguished faculty members, Professor B.M. Azad, Vice Principal, sir, Dr. Chandrasekhar Azad, Dr. Sanjit Prasad Chaudhary, Dr. Srimati Archana Anupam, Professor Ray Amitabh Sahai, Professor Pankaj Kumar, Professor Madhu Kumari, Professor Abhishek Anand, Professor Seema Kumari, for their classic focus on the subject matter. I extend my special thanks to Madam Astha Suman, Program Coordinator, who delegated me such types of golden chance to express my heartiest vote of thanks. Many thanks to Professor Astha Suman, millions and billions times thanks. I am thankful to our technical staff and the non-teaching employees, Sri Rakesh Kumar, Sri Pankaj Kumar, Sri Vivek Kumar, Sri Ujjwal Kumar, Gopal, Suresh, for their better cooperations to make the program success. I once again express my welcome benedictions and blessings to Pankaj, who shall be the next door pillar of these institutions, and is honest and best effort like this, which is highly inspirable. Thanks, Pankaj, once again. I forward my thanks and blissful blessings to our endeared students for their patient and peaceful listenings. At last, I would like to cite two lines of written by famous US poet S.W. Longfellow: in the world's broad field of battle, in the bivouac of life, not be the dumb driven cattle, be the hero in the strife. Once again, thanks, sir. Many thanks. And I hope our respectable guest shall give their valuable time in next program also. Thanks, sir.